Which part of that? Yes? The effect of constitution. Okay, some discuss about object. The question is not about object, although I mentioned the word object doesn't mean that it's about objective. What is the effect of the constitution? So effect of the constitution is that is create a contractual relationship between the company and its member. Constitution shall become the constitution. So the legal effect of the constitution, the company may adopt constitution, and once it's adopted, that the constitution shall now bind the member and the company. Okay, so it's a contract among member and the company, right? So your discussion on that, and members can require the company to comply with the constitution in their position as a member and the company. Case Pender Lushington, contract between company and its member. So case for that is Wood and Odisha company. Member can force another member to comply with the constitution, but it's not a contract between company and non-members. Okay, right. Case important, Ellie against Positive Government Security Life Insurance. Although the outsider cannot prevent the company from altering the amend the constitution, the third party can still seek remedy. Southern Foundries, if they have a separate contract. Okay, right. So now, who is Farid? Is a outsider. Can the company can remove the clause 10? Okay. Although it's affect Farid's positions, outsiders. So here about the effect of the constitution is create a relation between companies and members only, not in the capacity of outsider. So the position in the clause 10 is about outsider. Farid is to appoint as a legal advisor of the company for 20 years. So Farid is an advisor, not member of the company. The position there is not member related. Okay. If anything about member related, then yes, the member, if the clause is removed, member can take action. But it's nothing to do with member's position. It's talking about legal advisor position. Legal advisors are outsiders to the constitution. So in that capacity, we apply the case of Alice. We can say that clearly that yes, the company can go ahead to amend the constitution. There's nothing the Farid can do here. Farid have no legal rights when it comes to constitution. He don't have rights in the constitution. Okay, even if Farid is a member, still the company can go ahead change the constitution. Why? Clause 10 is never in the positions of membership. It's talking about legal advisor, solicitor. Solicitor is an outsider. If the company is changing anything of the member's position, yes, member can have the right. For example, dividend must be given in cash. If the company want to change that, the member can object because their right is being affected. The member's position is affected, member can, but here, outsider position. Legal advisor is outsider. Director is outsider. Employee is outsider. Nothing of that concern can be draft into the constitution. So therefore, we say that on that ground, yes, company have right to change alter their constitution at any time, as long they pass the right resolutions, okay, to change that. Usually special resolution is required to remove that. If they follow that, then yes, they can change that. Okay. Right. So that's the discussion. Already stated that what are the area that required to read. Next. What topic is this? Yes? Okay. So now you tell me what you're supposed to discuss here. Area of law. Is it about ratification? Okay. Right. First, establish. Is this pre-incorporation contract? But before that, is that about means the action of promoter? Right. He wished to form a company and he successfully found investor for the company. That means this is action is promotion action. So first you're going to discuss about promoter. Don't go to pre-incorporation yet. Promoter. So who is promoter? Define promoter. Okay. Then you go into pre-incorporation contract. Okay. Right. So first you soundly explain who is promoter and what duties that owes, and then what is pre-incorporation contract? Contract entered into by the promoter prior to the company being registered. Okay, right. So on the 15th December, he signed an agreement with vendor, stated that payment of the property would be made by the company. So that means he entered into a contract with a vendor, means seller, buying a property for the company. Okay, so he entered on behalf. That is a promotion work, clearly. Okay, right. The company was officially formed on the 1st January 2023. That means after the contract has been entered. So obviously that contract is a pre-incorporation contract and started occupying the property. However, despite occupying the property, the company has not yet made any payment to the vendor. As a result, the vendor is planning to take legal action against John and Johan Jaya. So who do you think will be liable here? Why not Johan? First, you got to, in your law, that's why you explain promoter, you explain pre-incorporation contract, and you got to clearly establish when the pre-incorporation contract is liable, the liability by the company. And in what situation promoter will be liable? What if company failed to rectify? Who will be liable? Promoter will be liable. Okay, unless there's a special clause in the contract stated. Otherwise, that means it's more like a means what they call yes, agreement in contrary. They call that. That means they put a clause stating clearly that The person is entering into a contract on behalf of future company. Okay. And if the other party agreed and signed, then the Johan or the promoter will not be liable. Okay. But usually general rule is liability is the person who entered into contract. But here you cannot bind someone third party to enter into contract. So promoter is more like an agent as well. You done law of agency. Okay, that's why once the contract is entered, you're going to get the principle to rectify. The principle yet to exist at the time you enter into contract. Right. So where is the ratification? Is there a ratification? That's what the question. So if rectification, company bound. No ratification, John will be liable. Okay. So ratification can be express, ratification can be implied. So here is that rectification express or implied? So you got to explain that rectification can be two. One is express, that means they expressly stated either verbally by the board or the general members of the company, in writing the company, right? So either can be the board of directors or can be by the general members. But here there's no written ratification or express ratification here, either verbal or in writing. No. How will be reduced to the conclusion that that's the rectification? So we're going to look at implied ratification. So what to prove that or justify that there is an implied ratification? So the company occupying property indicate that they have impliedly ratified. The question the court will ask is, if you're not ratified, then why you gone into the place? Why you are doing the business from the place the promoter got for you, isn't it? Right. Similarly, if the promoter bought a vehicle and if the company failed to ratify, then the question is why the company utilized the vehicle. If the company utilized the vehicle, then that is implied ratification. So here, the ratification in the form of implied ratification when the company occupy and run the business from the premises which Johan has contracted with. Okay, right, for that. So that is understanding there is ratification, but in the form of implied ratification. So whether the liability, so in conclusion, we say that is there means a pre-incorporation? Yes, pre-incorporation contract. So what is the effect of the pre-incorporation contract? Here, the company shall be liable to pay the vendor for the contract that enter on behalf because of implied ratification. And you have last conclusion. Would your answer differ if the agreement signed by the Johan contained the following clause? Johan is not responsible to make any payment to the vendor. No, in the contract, when the time he entered into contract with the third party, he said that I'm not going to make the payment. Okay. Even if you use this clause, this is not agreement in contrary. Agreement in contrary must be very specific. I think you have done terms of contract exclusion clause. Okay, excluding liability in contract. Okay, so when you are doing an exclusion clause, the profferent, that means the person who creating the clause, exemption clause, must clearly state what they are exempting for. Here is very subjective. You say John is not right. Responsible to make payment for what? So you must state that I'm entering into contract on behalf of the company. If the company failed to ratify, please don't subject me to make the payment. That means I shall not be responsible. So that is the correct terms. Okay. If the company failed to rectify, so that means you give clear indication that you are entering into a contract for a future company yet to be formed. Once the company formed, the company shall be liable to take the liability. Failing which, you cannot subject John to make the payment. Okay. So if you can reconstruct the phrase, then yes, that is proper exemption clause. But this exemption clause very ambiguous, unclear, they call that. The term is not clear. Okay, I'm going back to your law of contract because pre-incorporation contract is about contract as well. Okay, the term of contract still applies here. Section 20, ultra-virus. Direct question, isn't it? Doctrine of ultra-virus. Just copy and paste from the topic on ultra-virus. Again, it's a topic on constitution. Okay. The effect of ultra-virus. When you do your object. Right. So it's supposed to be what is object. When it's become ultra-virus. Case of Ashbury Railway. Constructive notice no longer feasible. That means no longer valid in the modern days. Okay. Right. That's it. Up till that. So if you go back, you have summarized that. And remember this, then I don't think that it's a problem. I say that go back, do a mind map. Those places are given. Okay. You have luxury of knowing the topic in specific. Not all the time. If you are in a doing ACCA, MIA, they don't. You got to cover the entire topic. Okay. All right. Next. Lifting of veil of incorporation. So here, I'm not asking statutory. I already say so because you can see this term here. Say common law. So which is lifting of your common law, but I still go back to your basic that separate legal entity. So first you explain what is separate legal entity briefly, then you go to your explanation of these virtues that I mentioned in the past. Okay, judicial lifting, that means common law lifting of veil of incorporation. So point one, company used to avoid legal or existing legal duty, committing fraud. Case for that. So each one of them, each company can use avoid legal duty. Case for that is Guilford Motor. If a company is used to avoid contractual duty, again, official shall be liable. Case for that is Jones and Littman. So if you summarize this in a very key points, so can be composed into almost 10 points. Again, holding and subsidiaries. So these are situation or positions where lifting of corporate veil is possible. Okay, and you can subject those behind the veil will be liable for the action or wrongdoings they are committed against the company. If a company is set up for any illegal purpose or improper purpose, the officers and the members can be held liable as well. Case Lim Kabi. If a company ignore the doctrine of separate legal and personality, transfer asset from one company to another, again, officer will be subject to liability. You can get two cases there. You can mention any one of the cases sufficient. Every company in a group of company is separate. If in a case that you see that company having a clone sort of companies, okay, that means the exact directorship and share ownership in the same company, which is subsidiary, that never considered as a separate entities, that is a single unit. Okay, again, the court will lift the corporate veil. So corporate function as a single economic unit. So case famous for that is Hotel Japuri. Right, up till that. And you have a choice as well. You can skip any one of these topics. So your important partnership and any 4 topics. So I would go for constitution because there's 2 cases, and I go for separate legal entity, or again 2 questions there. Complete that. So now you know how you perform. And don't come and bother me why get lower mark and all that. They don't give me guns and others. Right, so this is week 12. 3 weeks from now means 3 weeks from now will be going to be a week. Before 2 weeks before exam. Final exam, I'll again do the similar thing. Okay. And you don't give me the similar thing. Right. And tomorrow is your submission, isn't it? Make sure that you do a better work. Even if you pass your, means what they call your coursework, that's your final exam is very important. Okay. Right. Any question from here? Whichever that I cover so far. Those who attend my class every day done a horrible work. What about those who had not attended? Really? They were giving me like a conjuring shock. Every page I can spill my heart can. I don't know what they discuss, what they talk. They talk about some other topic. Never thought. Okay, so you know who they are friends there. No, never. The guys at the back one. Okay. Lucky they passed their commercial law. They think that they already can easily cover this last semester, and some of you know that. Okay, there are also failures. I think one of your colleagues here in this class failed the paper. That's why it's doing second time. Right. So don't, and he's still not attending the class. Okay. Right. Okay. Any question from those from KB or JB? Right. So hope you submit your work on time tomorrow. Right. Um, for JB, this is your QR code for today. Okay. Next. Minute. Give me just a moment. Just give me a moment. Right. For KB, this is the QR code. Okay, done.
Thanks, sir.
Next is okay for Shalam. So guys in JB and KB, if you're done, you can leave the session.
Thank you, sir.
Thank you. I see you next week.